Good evening and welcome to Courts Today by Live Law. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. Starting with the updates from the Supreme Court. In a public interest litigation filed by former Rajya Sabha MP Dr. Subramaniam Swamy seeking to delete the words socialist and secular from the preamble to the Constitution of India, the Supreme Court today asked if the preamble could have been amended while keeping the date intact. The petition challenges validity of insertion of words socialist and secular in the preamble via the 42nd constitutional amendment during the time of Prime Minister Indira Gandhi. It is argued that such insertion was beyond the amending power of the Parliament under Article 368. The petitioners claim that the framers of the Constitution never intended to introduce socialist or secular concepts in democratic governance. Rajya Sabha MP Binoy Vishwam of Communist Party of India has filed an intervention in the matter opposing the petition by saying that secularism and socialism are inherent features of the Indian Constitution and hence the addition of these words in the preamble did not alter the nature of the Constitution. During the hearing, the bench of Justices Sanjeev Khanna and Dipankar Datta asked the counsels to consider from an academic point of view if the preamble could have been amended earlier to include the words socialist and secular while keeping the date of adoption, that is 29th November 1949, intact. The case has now been listed for the week commencing from 29th April. Stay tuned. You might be aware that recently there has been some controversy around the judicial actions taken by Justice Abhijit Gangopadhyay of the Calcutta High Court. Last month, he had defied a stay order from a higher bench regarding his order directing a CBI investigation into alleged irregularities in medical admissions in the state of West Bengal. Additionally, he made serious accusations against another judge. The Supreme Court bench of Chief Justice D.Y. Chandrachud and Justices Manoj Mishra and Satish Chandra Sharma today heard a writ petition filed by Trinamool Congress MP Abhishek Banerjee requesting for necessary action against Justice Gangopadhyay for politically motivated interviews. It also sought for transfer of the cases concerning Banerjee from the present High Court bench to a special bench. During the hearing today, CJI Chandrachud voiced concerns about admitting a request for action against a sitting judge of a high court for his remarks. Senior advocate Abhishek Manu Singhvi, appearing for the TMC MP, told the court about how Justice Gangopadhyay had made some remarks about another judge, Justice Amrita Sinha, that Justice Somen Sen had called her and gave her certain directives to dismiss the cases filed against Banerjee. Singhvi urged the court that in this backdrop, the matters ought to be transferred from the bench of Justice Amrita Sinha. The bench expressed disinclination to entertain Banerjee's petition but agreed to consider other reliefs sought in the petition. It stated that Banerjee's petition will be tagged with the suo motu case initiated by the Supreme Court, in which the cases concerning medical admissions scam were transferred from Calcutta High Court to the top court. The bench also agreed to tag his request for a transfer of the proceedings before Justice Sinha with the 5-judge suo motu action against in light of the row between Justice Gangopadhyay's bench and a division bench comprising Justice Somen Sen. While hearing a plea concerning Muzaffarnagar student slapping incident, the Supreme Court today expressed displeasure with the state of Uttar Pradesh for not complying with the suggestions given by Tata Institute of Social Sciences in its report for counselling of students involved in the act. Directing the state to immediately implement institute's suggestions regarding counselling of other children who were participants or witnesses of the incident, the bench of Justices Abhay S. Oak and Ujjal Bhuya said that the suggestions have to be implemented in letter and spirit. The case relates to a primary school teacher in Muzaffarnagar, Uttar Pradesh, punishing a 7-year-old Muslim boy by instructing other students to assault him ostensibly as punishment for poor performance in multiplication tables and making alleged communal remarks. The Parliament has approved the Constitution Scheduled Castes and Scheduled Tribes Orders Amendment Bill 2024 specifically for scheduled tribes in Odisha. The bill has swiftly passed through both the Rajya Sabha and the Lok Sabha within a span of 2 days. It aims to amend the Constitution Scheduled Castes and Scheduled Tribes Order specifically for Odisha. The proposed modifications include incorporating recommendations from the Odisha government to add 4 particularly vulnerable tribal groups, that is PVTGs, directly to the state's scheduled tribes list. Additionally, it allows for inclusion of certain communities that are phonetic variations of existing ones. Furthermore, 2 communities are proposed to be shifted from the state SC list to the ST list. Let me tell you, the Constitution originally notified the lists of scheduled castes and scheduled tribes in 1950, with modifications made over time. Notably, the ST list for Odisha was last modified in 2002. The state hosts the largest number of PVTGs in India. Though the government had previously launched initiatives to improve their socio-economic conditions, but only now these groups have been considered for inclusion in the scheduled list. In a similar development, paving way for addition of new communities to the list of scheduled tribes for state of Andhra Pradesh, the Parliament has cleared the Constitution Scheduled Tribes Order Amendment Bill 2024. You can visit our website for more details on the same. State of Kerala has filed its reply affidavit at the Supreme Court in response to the written note submitted by the Attorney General for India in the suit filed by Kerala challenging limits imposed by the central government on the state's borrowing powers. While the state of Kerala challenged the centre's actions as an infringement of the state's fiscal autonomy, the Attorney General defended them as measures necessary to protect the macroeconomic stability of the nation. Raising concerns about reckless borrowing by states, the AG had said that the debts of the states affect the country's credit rating. He also blamed the state for its financial stress, saying that they are the result of Kerala's financial mismanagement. In its reply, the state has now said that the Constitution does not confer any power to the union government to control the debts of any state. The state said that AG's note, which is not backed with any affidavit, is mostly rhetoric without touching upon the serious constitutional issues raised in the plaint. It added that the note made disparaging statements about the state's financial management in a myopic and misleading manner, although it is not an issue involved in the plaint. Therefore, the state contended that the statements in AG's note were intended to divert the attention of the court from core legal issues. The Supreme Court will hear the suit on 13th February to hear the prayers for interim relief. Stay tuned with us. The Supreme Court today remarked that lawyers should undergo a compulsory training program. The court made this remark after noticing certain lapses on the part of a lawyer in handling the bail application before the trial court. The bench was hearing the bail plea of Souvik Bhattacharya, son of TMC MLA Manik Bhattacharya. Souvik is facing charges under the Prevention of Money Laundering Act for his involvement in the teachers' recruitment scam in West Bengal. Despite no official summons from the court, he voluntarily surrendered. However, both the trial court and the High Court have denied him bail. Senior advocate Siddharth Luthra argued that Souvik should not be detained without a summoning order, emphasizing that while the trial court acknowledged the offence, there had been no formal summons issued for his appearance. Souvik has filed an SLP seeking bail, challenging the High Court's order. Luthra accepted the mistake committed by the lawyer who had filed a bail application on behalf of Souvik before the trial court. During the proceedings, Justice Bila Trivedi proposed establishing a law academy for lawyers similar to those available for judges to ensure they receive proper education and training. She emphasized the need for compulsory training courses for lawyers, both junior and senior, suggesting that lawyers should also undergo training similar to judges at institutions like the National Judicial Academy. After repeated submissions made by the Additional Solicitor General S.V. Raju that Souvik had surrendered in compliance with the summons issued to him, Justice Trivedi disagreed by noting that summons were issued but without the order of the court. Although the court was inclined to release Souvik on bail, but it has granted a week's time to the ASG to verify the order of the trial court. The Supreme Court today issued notice in a petition seeking transfer of impending trial in the 2015 cash for votes against the present Chief Minister of Telangana, A. Revanth Reddy. Underscoring the need for a free and fair trial, the petition has prayed for transferring the case to Bhopal, Madhya Pradesh. The petition was filed by former ministers, including the former Deputy Chief Minister. The cases against which the transfer was sought are pending for trial before a special judge in Telangana. The petition claims that Reddy allegedly offered a bribe of 50 lakhs to MLA Elvis Stephenson during the 2015 Telangana MLC elections, allegedly on instructions from his former boss N. Chandrababu Naidu, who is the former Chief Minister of Andhra Pradesh. It is alleged that Stephenson was asked to either abstain from voting or vote in favor of the Telugu Desam party. The petitioners assert that the accused were caught in the act by the Anti-Corruption Bureau, but express concern that the main accused is Telangana's current Chief and Home Minister, potentially affecting the fairness of the trial. They request a transfer of the case to an independent state to ensure a fair trial. The matter was placed before the bench of Justices B.R. Gawai and Sandeep Mehta, which issued notice in the petition. Veena Vijayan, director of IT company Exalogic Solutions and daughter of Kerala Chief Minister Pinarayi Vijayan, has filed a petition before Karnataka High Court seeking to quash the order passed by the Union of India directing Serious Fraud Investigation Office, that is the SFIO, to investigate the company. Exalogic Solutions faced controversy after reports revealed that Cochin Minerals and Rutile Limited, that is CMRL, allegedly paid 1.72 crore to Exalogic Solutions from 2017 onwards. An order by Income Tax Interim Board of Settlement indicated that CMRL made these payments without receiving any services. This raised allegations that the money was actually kickbacks disguised as payments for IT services to the company. The petition filed now states that the impugned order directing SFIO to investigate Exalogic has been passed pursuant to an order passed by the Union of India through the Ministry of Corporate Affairs under Section 212 of the Companies Act. This is despite the pendency of an investigation under Section 210 of the Act. Let me tell you, Section 212 pertains to investigation into the affairs of a company by SFIO, and Section 210 deals with investigation into company affairs by the registrar. The petitioner argues that an investigation under Section 212 of the Act cannot be ordered before conclusion of investigation under Section 210. The petition further alleges the order to be arbitrary, lacking reasons, and demonstrating a significant lack of consideration. Additionally, it is argued that the order violates principles of natural justice and appears to be motivated by malice. And lastly, the Supreme Court today dismissed a petition seeking contempt action against the Election Commission of India for not changing the forms which ask for Aadhaar numbers to enroll new voters. Last year, in response to a petition filed by Senior Vice President of the Telangana Pradesh Congress Committee, the Election Commission had given an undertaking to the Supreme Court pledging to make appropriate clarificatory changes in Forms 6 and 6B, which sought Aadhaar details for electoral roll authentication for new voters. The petitioner claimed that despite ECI's assurance last year that Aadhaar numbers were not obligatory for new voter registrations, the forms remained unchanged. It thus sought contempt action against ECI. However, a bench comprising CJI Chandrachud and Justices Manoj Mishra and Satish Chandra Sharma today declined to initiate contempt proceedings, noting the ECI's statement that it was addressing the issue. The bench also pointed out that the earlier petition was disposed of in the light of the undertaking by ECI that they were looking into the issue and that the court had not set any timeline for compliance. Also, let me tell you, a separate challenge to the Election Laws Amendment Bill 2021 and registration of Electors Amendment Rules of 2022 is currently pending before the top court. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.